Okay, everybody, welcome. I'm really excited to be with you today, presenting on a difficult topic that unfortunately has just gotten a bit more difficult for us as of July 24th, 2020, when USCIS released a long-awaited redeployment policy clarification and made it immediately effective with retroactive application to pending 526 and 829 petitions. That's not what we were hoping for and anticipating by way of clarification. So it's quite an ambitious presentation today. I'm going to walk you through some of the key highlights in the redeployment policy update. And also pivot then to comment writing. It is very important, I believe, for USCIS to hear from stakeholders about what we think of this redeployment policy update, the manner in which it was promulgated, the manner in which it is made effective, and the substantive content of it and how it affects us, primarily who we acted in reliance on the old written policy manual. And here we are with something that's very different and that is immediately effective. So let's go right to sharing my presentation, and we will move right through. So that's our title, of course. A minute about my EB-5 experience. I have a lot of it, and it's all on my website, so check it out if you're ever bored. Specifically, my comment writing experience is relevant here. I've written legislative commentary on proposed EB-5 legislation, immigration legislation, since S-744 in 2012. That was our last real stab at comprehensive immigration reform. S-1501, of course, penned by Chairman Grassley and Senator Leahy, that proposed to introduce significant reform and change to the EB-5 program. I've written congressional testimony on EB-5 regulations, written extensive comments on modernization regulations for various EB-5 stakeholders, as well as the advance notice of proposed rulemaking, which I think is an important notice, and US policy generally since 2009, when USCIS first shared its material change policy with us. So the roadmap to our presentation today is to cover the sources of the policy manual update, share highlights of the policy manual update, teach you how to submit comments to the policy manual update, and some recommended key points to cover in your comments. And we're going to try to reserve some time for Q&A at the end. So the sources, there are three. Policy alert that came out, and that's the URL for it. The policy manual itself, which is published online, it is a live guidance manual, if you will. And all of the updates are live on that manual as posted. And the USCIS Q&A that it posted shortly after the policy manual was updated. And the PowerPoint will be made available to you, so you don't need to take any notes. The highlights that we'll be covering, kind of going from what I think is the least important to the most important. Here are the changes. Securities sold in the secondary markets in the initial deployment, prohibited. Commercially reasonable time is given a bit more definition. Redeployment would be okay, seemingly, in any commercial activity consistent with the commercial enterprise's lawful purpose. Geography change, this of course is huge, and we're going to be talking about this in what to write in our comments. The new policy tells us that redeployment has to take place within the geographic scope of the original regional center. That's new. Material change, there is a section on material change that has also changed as a result of this policy manual, but we're going to go over that. There's some ambiguities there. And of course, the effective date. This is the big one. We have the policy manual going effective on the date of publication and applicable to pending EB-5 petition cases. We're going to be talking about that. So let's cover the first highlight quickly. Securities sold in secondary markets. As far as I know, this hasn't ever been a dominant use of EB-5 capital proceeds, but the service now says in the initial deployment, when you're first contemplating your business plan and use of EB-5 capital, that capital can't be used to buy financial instruments that are traded on secondary markets. Now, these are new terms to EB-5. They're not defined in regulations or elsewhere. So we have to try to unpack what this means. Secondary markets, as I understand it, is a term for publicly traded market floors, stock markets, in other words. So if that's correct, this seems to be saying in the initial deployment, you can't use the initial EB-5 capital to purchase publicly traded stock. And the reason given is that these transactions USCIS deems are primarily financial rather than commercial. Does anyone see the distinction there? I'm not sure I do. So we have a few folks raising their hands. Sure, I'm going to take a question. Lulu, do you have a question? You're muted. Write it in the chat box. We will have Q&A at the end.
No, I didn't have a question. I don't know why that looked like I did. Sorry.
No problem. I'm going to come back later.
Okay.
Okay, so I'm actually going to take a quick poll here because I'm curious. How concerned are you about the immediate effect? Oops, that's not the right one. Let me go back. This is the one. Are you concerned about not being able to buy stock in secondary markets in the EB-5 EB-5 initial deployment? %8 of you said you were, and 92% of you said you weren't. So our expectations are proven out. I don't think we're really worried about this one, okay? But it's worth noting. It's worth noting because of the rationale. The service says this doesn't count, this doesn't work because it's primarily financial rather than commercial. So that's telling me that our transactions are going to have to be deemed commercial by USCIS to qualify generally. Something to look out for as we go. Okay, this is helpful. Commercially reasonable time. We all wondered, what does this mean? Is it 6 months? Is it 12 months? Could it be 24 months? What's commercially reasonable? How much time do we have before we have to launch our redeployment from the time of repayment is how I interpret the start of the clock to redeploy within a commercially reasonable time. The service now says 12 months will be generally considered reasonable, but rather generously, it says that longer time to redeploy will be considered based on the specific facts under the totality of the circumstances. I'm going to take another quick little poll here. Commercially reasonable time. Do 12 months seem reasonable time to redeploy? Okay. So 86% of you thought yes, 12 months seems reasonable. Only 14% of you said you didn't think that was reasonable. That's very helpful feedback because, and it does confirm at least my sense of what folks in the industry were feeling. Because if we thought that 12 months was too short or otherwise problematic, this would be a focus in our comments. Okay. But it's not. I think we are generally in agreement that 12 months seems okay. And there's this wiggle room as well. Any commercial activity. So the service says in the policy alerts, kind of giving some gloss to these updates. It says the service wants to clarify prior confusion about the scope of the new commercial enterprise. This language was in the June 14, 2017 original iteration of the redeployment policy. And gosh, we all scratched our heads about what could this mean? A lot of the operating agreements and the LPAs, partnership agreements of new commercial enterprises, had very general language, as is permitted, any lawful conduct of business activity. So does that mean anything is okay? But that didn't feel right because there seemed to be other constraints, particularly in the examples given about residential construction and new issue municipal bonds. So the service says, we're trying to give you clarity on this. And it seems to be expanding this notion of what might qualify for redeployment activity. It says it has to be consistent with the purpose of the new commercial enterprise to engage in the ongoing conduct of lawful business. So on its face, it seems expansive and open and not limiting. I think it's worth us trying to get clarification there, but that seems to be the intent. Notably, there is a new legal rationale for this redeployment standard, if you will. And the new rationale, as I read it, is that the activity, the permitted redeployment activity, is going to be keyed to the definition of commercial enterprise in the regulations, rather than the investment at risk standard in the regulations and precedent decisions, notably matter of Izumi. I think this is significant, and it addresses a key worry of mine and a key point of advocacy for me since redeployment policy came online. We're going to go into this a bit more, but grounding redeployment in at-risk was very problematic from a legal rationale standpoint because at-risk analysis has nothing to do with the redeployment transaction as contemplated in the policy manual and as we understand it. So this change, I would submit, is progress. In contrast, geography, this is a new change. It says further deployment, FD, must occur within the regional center's geographic area. Now, we know this wasn't in the prior written policy guidance. The reason the policy manual gives is that further deployment must continue to meet all applicable eligibility requirements within the framework of the initial bases of eligibility. Okay, so let's unpack this just a little bit. Further deployment must continue to meet all applicable eligibility requirements within the framework of the initial bases of eligibility, but it also says you don't have to have the same job creating entity. In fact, you don't need a job creating entity at all. And it doesn't have to be within a TEA, which are fundamental aspects of the initial bases of eligibility. So why has the service cherry-picked geographic scope of the original regional center as an initial basis of eligibility that must be maintained on redeployment? Material change, this is another one. And it's not much discussed, but I think it's very worthwhile to look at. This comes up in chapter 4 of the policy manual. in its discussion of material change, there is a little change inserted there. It's as if the investor changes the associated regional center, whether during the initial or further deployment, that part is new, that change is material. And we know that if a change is material, then pending 526s are deniable, approved 526s are revocable. So there is no reason given for this little change inserted in Chapter 4. So the question is, does this refer to further deployment geography? Does this mean to say that if you are redeploying outside the initial regional center geography, that the service is going to deem that material change, and on that basis deny pending 526s and revoke 526 approvals? This is an important question, and it highlights a key point of ambiguity, important ambiguity in these policy manual updates that are effective right now. Effective date, this is it. I think this is the key issue, retroactive application. Policy manual came out July 24th, 2020 in an email and in a web posting. And it said it applies to all 526 and 829 petitions pending, filed before then, given USCIS processing times years before then. And this is stated in the policy alert and in the Q&A, so they mean it. There is no lack of clarity on this point. The reason is the service says policy update is merely a clarification, not changing any substantive requirements. We're going to get into that a bit in our discussion of comments. Okay, so those are the policy manual updates, the key ones in my view. How to write your comments. So I'm going to cover just the how-tos, and then we'll get into the substantive points. It's actually not obvious how to provide comments, and it's in a couple of different places, but not anywhere very obvious. So you'll want to go here. I think this site here has the best guidance on how to provide comments. You'll want to email your comments to this email address, USCIS Policy Manual, not IPO, not Office of Public Engagement, not USCIS Immigrant Investor, this email address. And it says to include the following points to make your comments clear. And I excised one bullet point, but it's basically this, and they're all listed if you go to that site. You've got to state the title of the policy manual, the relevant chapters. Listen up. It says the policy comments are due before August 24th, 2020, which is next Monday. Before. So I think comments need to be submitted by August 21, which is this coming Friday. And I think I'm going to be submitting my comments by close of business on the 21st, just in case. Here's what you want to put in the subject line as requested. This is it, USCIS Policy Manual. It's volume 6, part G. And this is what I'll be writing in the Ray line. And you are welcome to copy and paste it. Comment to the policy manual. It affects chapters 2 and 4. And here we go. All right, now your comments. The key points to cover in your comments from my perspective, based on my experience. Generally, you want to give them two kinds of feedback. Good job, this is good, or not good, please do over. And you want to keep in mind what your goal is and keep coming back to it. And I think that for comments to the policy manual, we have two goals. One is rescind the portion of the policy manual update relating to the geographic limit after job creation. Or more modestly, keep the geographic limit, but make it perspective only, please. The second point I think we want to make is engage in prospective rulemaking, please. This effective on the date of publication, by email, by website posting, with retroactive application, that just doesn't work. I also think that the tone and the manner of presenting the comments is quite important. We're engaging with a government agency that regulates our industry. And so I always try to take a respectful and professional tone and use that same language in my comments. And I think it's important to get the points across to be persuasive. And I also think that the balance of good job and please do over is also important. And in fact, it's in their agency internal guidance that public feedback and comments can really be set aside if it feels like they're coming from a place of bad faith or it sounds unhinged. So we want to come across as professional, persuasive, serious, and respectful. Okay, so the first point I think is good job on moving redeployment guidance away from investment at risk rationale. It made no sense in the redeployment context, as I feel like I've said till I was blue in the face. So I'm personally gratified that we've got a change here. You may not be able to make out the tiny, tiny print. It doesn't matter. The graphic is meant to show why at-risk rationale was so misplaced, because on the left, this is the investment at risk transaction. It's about the investor and the new commercial enterprise and the contribution of capital. That's investment that has to be at risk. Versus here's our redeployment transactions. We have the deployment, initial deployment to the job creating entity. We have repayment, that's the blue arrow. And then we have reuse or reinvestment of that repaid EB-5 capital proceeds. So this is down here. This is not investment. This has nothing to do with investment. So good job, USCIS. Good job adopting the commercial enterprise definition as rationale for redeployment. This has been a longstanding point of advocacy on my part because it makes more sense and it's not made up. It's actually already in the regulations. Redeployment is about regulating what the new commercial enterprise does, not what the petitioner investor does. It's not about the investor NCE transaction. So this makes a lot better sense. And the regulation is defining commercial enterprise is at 8 CFR 204.6E. Do over, back to the drawing board on the geographic limit after job creation. And I think that this, as the public, is the point to hammer home, the serious reliance. We relied on the only authority we had, which was the written policy guidance promulgated June 14th, 2017. Why do I think this is so important? Because the service's justification for issuing the policy update as mere clarification and therefore not requiring any notice is that it thinks that the impacts are minimal. So we've got to disabuse the agency of that notion. The impacts are serious. And so I invite you in your comments to state your facts. I think it's important for the agency to hear that. I think it's important to have those concerns on the record, and it could be helpful to your case specifically down the road, depending on what posture you may find yourself in, defending an RFE, notice of intent to deny, or quite possibly in litigation. Commercially reasonable. So these are the points to make in connection with the geographic limit after job creation. So we were kind of set up, weren't we? Because the old policy guidance said, you got to redeploy within a commercially reasonable time, which we're not going to define. So we had to redeploy, and there was this urgency to redeploy and to comply with the commercially reasonable time. And indeed, clarification on all aspects of the policy was requested from the get-go. I can tell you I authored June 28th, 2017, comments from the American Immigration Lawyers Association, extensively cataloging the issues and the open questions. So we requested clarification. Clarification is now provided, but 3+ years after the initial guidance. Now, this caret here is my symbol for 3+ years is greater than commercially reasonable. We could not wait for this clarifying guidance. Folks acted in good faith on the guidance we had. I think these are very important points for us to make. June 14, 2017, written guidance. It was the sole available authority we had, and we did our best. Continue on the do-over on the geographic limit aspect of the policy. So I think these facts are important to get into the record. At the November 19, 2018 public stakeholder meeting that IPO held, we first got an alarming inkling, as I will call it for this presentation, of the geographic limit expectations on the agency's part. And anyone listening to the recordings will know that this came as a shock, and we asked for clarification right away. The agency declined to give that clarification on that occasion. So there's no choice, good faith compliance to the written policy we had. And yet we have a major change. To go from nothing, silence on geography, to a restriction on geography made effective immediately. That is a major change, and it is substantive. It isn't clarification when you said nothing, and now you're saying something new and different, or I should say new, not different. So this isn't embellishing a point that was made before. This is a new point. So this is substantive. And there was no notice of comment, but the new policy affects our substantive rights and requirements. So the point here is that it violates Administrative Procedure Act rulemaking. The APA requires, unless it's general statement of policy or a mere interpretive rule, if it's substantive, if it's binding, it's got to go through APA rulemaking process. This is the point that I personally will be hammering home, is the procedural defect of this. Do-over continued on the geographic limit. So this goes into the substantive. We've talked about the procedural problems with the way in which the geographic limit was rolled out. Substantively, look at congressional purpose of the redeployment of the initial deployment in the regional center geography is entirely satisfied once there's completed job creation. That's done. There's no authority that the service can cite to, or anyone, to say that redeployment has to occur within the regional center geographic limits. It doesn't make sense after job creation. It's all done. The purpose of putting investments in a regional center geographic scope was to promote economic impacts arising from that job creating activity within the bounds of the regional center. Well, we can check that box. And this is made patent by the fact that a job creating entity is not required, nor is redeployment in ATEA required. So again, how to make sense of the regional center geography being required to be retained. It lacks sense and logic. So these are points to make in your comments. Do-over continued on the geographic limit. Now, these are what I would generally consider not as persuasive as a legal argument, but because of the importance of the reliance argument in this context, I think that it is important for us to flesh this out if we can. From a project standpoint, I think these points are readily made. The practical policy reasons against this policy being made effective. I mean, suppose a project gets repaid, but there is no viable way to place that capital, repaid capital, within the original center geography, the original regional center geography. We see this because, especially in a down economy, even in metropolitan areas, there may be no viable redeployment opportunities. And certainly in rural communities, there might be very limited redeployment opportunities. And what then? So the NCE manager is called to risk loss of capital, potentially breach its fiduciary duties to preserve capital, and risk exceeding the 12-month benchmark on doing its due diligence to try to place this redeployment within the regional center geography. And for what? No rational good reason that anyone can find, as far as I can tell. Related point, do-over on the effective date and retroactive application. We can let them have it on this because it's so egregious and it all ties into the serious reliance point. Unfair, contrary to due process, lacks integrity in the sense that you said one thing was okay and now you're saying it's not, and you're going back to everything we did in reliance on you being silent on the point, and possibly bad faith as well. Again, we were set up to fail by the terms of the original policy manual and the restraints of commercially reasonable time for redeployment. And so that plus the retroactive impacts just does not feel right. How was minimal impact to investors determined? I think it's important to take the agency to task on this because this is the rationale for promulgating this policy without any notice and making it immediately effective and retroactive. How do you know that there was minimal impact? Because it doesn't feel minimal, it feels pretty major and substantive. So this is the opportunity for investors to come to the fore if you're writing comments, and I hope you will, and your representatives, state your facts. How is this harming, prejudicing your immigration case? Your I-526 processing times are 46 to 74 months as published on the USCIS website. So the service policy update says that it is going to deny these cases that have been pending for years if your NCE redeployed outside the original center geography in good faith. When these cases were approvable at the time of filing, a gross reversal of fundamental rules relating to agency conduct and adjudications. Age out children. If you have children who are going to age out, if you've got to go to the back of the line, need to speak up. And what if your case is denied because of maybe it's material change, because of the redeployment happening outside the regional center geography after filing? You've got to refile at the 900,000 level. So let the agency hear from you. Effective date and retroactive application pointers continued. We have this policy, it binds us all now, but there are many questions yet remaining, many critical questions. What about conditional permanent residents? Are they safe if they redeployed outside the regional center? Because they're mostly safe from material change challenges under the policy. We need an answer to this. How are pending I-829s affected? These are all petitioners, investors who are in conditional permanent residency. Many will be at the end of their sustainment periods. So what does it mean when you say that this applies to pending 829s? This is important. What does it mean to say investments must be sustained at risk for 829 eligibility? Remember, the policy manual changes chapters 2 and 4. 829 requirements are in chapter 5. Chapter 5 still contains the changes made in the June 14, 2017 original policy that still has this at-risk concept in there that the service did not lift in the redeployment policy update. So we still have this at-risk language in there. I submit to you that it has no foundation in the law. So how are petitioners and projects supposed to comply with this now? Important question. Why no notice and comment? What is your rationale? How is this policy not substantive? How do you conclude that this new policy is mere clarification? Why was this clarification not made immediate after your public stakeholder call, when you heard from stakeholders that this was new and unexpected? I think these are some of the important points that you may want to write into your comments. Okay, so I'm going to get to questions, and I'm excited because we covered a lot of ground and we have time. So again, email your comments to this email address. I would say submit by this Friday. And now we're going to take questions. Okay, 1 second. All right, Lulu's got a question. Okay, Lulu.
Hey, hi. Yes, can you just go back to your good job about separating the at-risk from at-risk sustainment, investment, you know, I didn't get that that's what happened. So I want you to explain how you're reading it.
Okay. When you read chapter 2, where the deployment after job creation and even at deployment before job creation is discussed, we have the Izumi language in the initial deployment after job initial deployment before job creation, but we don't have that at-risk language in the deployment after job creation. And in a footnote to the section discussing further deployment after job creation, it says that you don't have to make the funds available to the entity most closely responsible for job creation anymore, which is Izumi. So that to me was further indication that it means to, that the service means to back away from the investment at risk rationale and instead recast redeployment policy in the new commercial enterprise definition. And also in the policy alert itself, it does talk about investments needing to be sustained at risk, which is still troubling to me because of the unedited language in chapter 5. But the second bullet point says, clarifies that capital may be further deployed into any commercial activity that is consistent with the purpose of the new commercial enterprise to engage in the ongoing conduct of lawful business. And that's what I had said from the beginning, that should be a better foundation as a legal matter for redeployment policy. The notion of ongoing conduct of lawful activity, which is in the definition of commercial enterprise. So do I think that we're out of the woods, if you will, on whether or not the service will continue to cite to matter of Izumi if it finds redeployment flawed? No, but I think that progress is made here.
Okay, thank you.
You're welcome. All right, I'm gonna open up my handy Q&A. We have questions here in the chat. I don't need my Q&A window. Lots of questions. Hello, hello. Okay, if the initial funds are repaid, it would be nice to be able to redeploy the funds into a REIT, publicly traded options to buy stock. Helps new commercial enterprises to manage redeployment risk and gives investors clear info on how and where funds are going and who is managing them. Does the new rule prohibit this under the secondary markets test? Even if allowed, it seems impossible to limit REIT assets to occur within regional centers geography. Well, so let's take this. So the service seems to say that buying stocks in the public markets is not okay in the initial deployment. Now we can read that as saying it is okay in the redeployment context. And that reading would be supported by footnote 1 in the policy alert, which says, this clarification supersedes prior language discussing new issue municipal bonds as a specific type of potentially permissible financial instrument in the context of further deployment. I would say that that footnote could be read as saying that is new issue municipal bonds in the redeployment context is okay, as is any commercial activity consistent with the ongoing purpose of the new commercial enterprise. I guess the concern might be on the other side, this notion of commercial activity. So it's the rationale to why the purchase of bonds, or I'm sorry, the purchase of stock in secondary markets is not okay in the initial deployment context, because the service says that it's purely financial and not commercial. So, and it looks like from the redeployment after job creation language that we still need to have commercial activity, right? So if buying financial instruments on the secondary market is not commercial and therefore wasn't okay in the initial, the question might be, so does that mean because it's not commercial, because USCIS deems it not to be commercial, perhaps, would it not be okay in the redeployment context? I understood what I said. I hope you did. Okay. If I have comments on multiple issues, is it better to make them one by one or in separate emails? Oh, okay. If I have comments on multiple issues, is it better to make them one by one in separate emails? In previous experience submitting comments, I got the impression that USCIS would only pay attention to 1 or 2 points in my extensive analysis, and that I might be making a mistake in 2 long comments, but not sure that's the best strategy. I don't know the answer to that, Suzanne. That's a really, really good question. I think that substantive comments delivered in the right tone, with good analysis, with the information, data, legal authority that the service requests in public comments, that that they should be read and they should be responded to. Now, whether they should be delivered in chunks or in one long, I tend to think that if it's from one source, that it could be viewed as sort of, gnats coming at you if you're delivering lots of missives. So if it's from just one party, I would say deliver your points all in one document, in one comment, but try not to belabor the point, which is perhaps rich coming from me, because I do tend to write a lot. But I am trying this time to not belabor the points, to move through, because I don't want these comments to be ignored. I think that volume does matter. I think the more people write in this manner, substantively, respectfully, etc., that will have more weight. But kind of adding to bulk from one party, I don't think that would. I got around to coming up with an answer to that one. Okay, do we have other questions in my Q&A box? Looking at USCIS comments page, it says closing dates for comments are extended to August 24th. So why do you think it ends on August 23rd at 11:59? It actually says, go take a look at the, I would love to be wrong. I'd love to have the weekend. I would love to have everybody have the weekend. But take a look at that language. It felt, just worried about it because it says that the comments have to be delivered by close of business or something like that before the date on the above chart, before the date on the above chart. So before the date, that to me read conservatively is before August 24th. Now, so if you submit them on, it's email after all. So if you submit them on August 23rd, Sunday, would that come under that language as conservatively read? Perhaps, but it's not a business day. And so being somewhat paranoid, perhaps it's best to shoot for getting them in on the 21st. From a participant, a very respected industry leader, the website says you must submit your comments before the closing date noted on the table above, which he didn't see until I mentioned this. So yeah, I mean, I think I just don't know if we want to risk getting them in on the 24th. Ah, hello. Hi, Ashley. Okay. Do we have any other questions? Looking at the same page, USCIS, are we all looking at the same page? This is my point. This was my point, David. That it is the guidelines on how to post or send your comments are in in 2 or 3 different places, and they all do not say the same thing, which makes one concerned that a stakeholder could be following instructions on one area of the website, and then the comments would be disqualified because it didn't meet the requirements set forth somewhere else on the website. So for that reason, again, taking the most conservative approach might be. Do I think that they would? I mean, let's just imagine this. So the agency says we're going to ignore comments received, particularly if the vast majority are received on the 24th. So perhaps as a practical matter, they wouldn't ignore, the agency wouldn't ignore comments delivered on the 24th. I don't know. I think we're each going to have to play that one consistent with our comfort levels. What's your best practice suggestion to those projects that have already redeployed out of the original regional center's geographic area? Well, this really is the 900,000 times the number of investors question. I think that putting into place a full reversal of that redeployment, first of all, that's not practical in most cases. These are binding transactions, and these are points that you might want to also make in your comments. New commercial enterprises have entered into binding transactions, agreements, commitments with these entities into which they're redeploying. The money is there, and there is no recourse to getting the money back. So I think that it's yet another reason why this policy just is wrong and makes no sense. But in terms of what you do, so you can't, or perhaps your documents do permit you to claw back under certain circumstances, and you think these circumstances may be those governmental actions. I don't know if full reversal, getting the money out and finding somewhere to redeploy it to within the original center geography right away is necessarily is necessarily the best course of action. We have the policy because of the stakeholder reaction as we see it to this redeployment policy update. I am hoping and anticipating that there will be a lot of comments delivered to USCIS protesting the manner and the content of this policy update. And I hope that the agency will take these comments into consideration and either rescind the geographic limit portion of the policy and engage in formal rulemaking as it should, or at minimum, make that portion of the policy prospective only. If it does that, then your transactions should be good. On that point, we would want the agency to also clarify that it's kind of giving a continuity to compliance. So service shouldn't deem, okay, from July 24th to whenever this rescission of the policy came about, you were non-compliant, and so those petitions are going to be deniable. That would be absurd. So to the extent that we want the service to clarify that there's going to be continuity of compliance, if we get that, I think that would be good to get that clarification. So I'm hoping that the service will rescind and at least make prospective the geographic limit. That all said, I also think that it is best practice to not, certainly to not ignore this policy, which is effective right now, and to take good faith actions to conform, to accommodate your redeployment transactions to this policy. So it's internal conversations, it's analysis, it's attending these sessions, it's talking to your counsel, it's writing memo to your file, it's doing diligence on your redeployment prospects within the original center geography. It's gaming out the time frame for how that might be executed. So I think that those are actions in good faith that a new commercial enterprise manager can and are taking to conform, to comply with the new policy. Whew. That's a really good one to end on. We're almost at the top of the hour. Everyone, thank you so much. And I will be finding a way to deliver the PowerPoint to you all. And I wish you good luck and good writing. The pen is mightier than the sword. Have a great rest of your day. Bye-bye.